So my name is Harley Moore Wilson. I am a member of the Native uh, Agricultural Financial Services team, and I will be your webinar host for today. And so the funder for today's webinar is through the Ag FTAP program, Agricultural Finance, Tax, and Asset Education Program. And this is to help both farmers and ranchers understand both their financials and how to be able to finance some different aspects of their business. And so today's presenter is Mr. Ridge Howell. Mr. Ridge is the legal counsel for the Native American Agricultural Financial Services. And prior to joining our NAFS team, Ridge served as the counsel to the Intertribal Agricultural Council. While he was at IAC, he helped coordinate outreach and technical assistance to Native producers eligible to apply for the USDA's Discrimination Financial Assistance Program, a program that Congress authorized in Section 22007 of the Inflation Reduction Act for the purpose of providing financial assistance to ranchers, farmers, and forest landowners determined by having experienced discrimination in USDA lending programs. I will let Ridge go into a little bit deeper dive of himself, but at this point, I will let Ridge take it away. I have one more housekeeping comment. We're gonna keep all questions until the very end. If you don't want to lose your question, feel free to put the question in the chat, but Ridge is going to address all questions at the very end. So go ahead, Ridge.
Thanks, Harley. Okay, good morning, everyone, or I should say good afternoon. Thank you for joining us today. As Harley said, my name is Ridge Howell, and on behalf of NAFS, I want to welcome you to our presentation on the Chapter 12 Toolkit, which is a guide to navigating farm bankruptcies. Agriculture and commercial fishing aren't just businesses, they're vital cultural and economic backbones for so many communities, but they face highly volatile economic conditions often outside of a producer's control. Today, we're going to walk through Chapter 12 of the Bankruptcy Code, a specialized, highly flexible, but often underutilized tool that's designed to help keep the family farm intact while giving you breathing room needed to restructure debt, alter production models, or successfully transition to the next generation without facing outright liquidation. We're trying to answer a couple simple questions, or maybe simple, we'll see at the end of this. But one, what is bankruptcy? And two, does it address your financial needs? On a high level, bankruptcy is a financial and legal process. It's designed to help those who can no longer pay their debts get a fresh start. And it can be kind of a cringy or unsettling word, but it's really misunderstood as a type of failure, when in reality, pursuing bankruptcy can be a smart risk management and restructuring strategy for people who want to start over and stay on their farm. To understand the power of Chapter 12, we really need to look back at why it was created. It was born out of intense economic survival. In the late 1980s, the American ag sector suffered one of its worst crises. It came from a devastating combination of falling land values, collapsing grain prices, and sky-high interest rates, followed by a sudden tightening of institutional credit that pushed thousands of people to the brink on their family farms. Pretty famously, farmers took to DC in the 1980s for some direct action. They drove their tractors into DC to demand structural relief, and Congress listened. In 1986, they enacted Chapter 12 as a temporary emergency reorganization tool that was specifically engineered for the unique cash flow and asset structure of family farms. Recognizing that it's an ongoing necessity to protect the nation's food producers, Congress officially made Chapter 12 a permanent fixture of the Bankruptcy Code in 2005. So, what kind of pushed us into the conversation about bankruptcy today? Why are we having it right now? Because historical indicators for at least the last decade have shown that we're trapped in a familiar economic cycle, and it's been bubbling. Following a period of record high farm incomes between 2010 and 2011, the sector experienced a steep inflation adjusted income drop. It was at 34%, which represented a loss of over $50 billion between 2012 and 2016. When you pair this with staggering debt and compressed operational net income and high interest rates, it creates a system that puts an increasing number of producers in tight spots where they just can't generate enough cash flow required to service their debt under their original terms. Now, roughly 10 years later, the 2026 data makes it clear that the strain has broken out into the open. Just a few months ago, in February 2026, the American Farm Bureau, Federation, and the Federal Reserve issued a joint warning predicting a major multi-year surge in Chapter 12 bankruptcies. The raw numbers from last year back this up. In the calendar year 2025, 315 family operations filed for Chapter 12 protection. This represents a 46% year-over-year increase from 2024, marking our third consecutive year of escalated filings. Ag economists describe this as a perfect storm. We're looking at a projected fourth consecutive year of declining net farm income, depressed commodity prices, especially for staples like corn, soybeans, and rice, and near record high operating and production expenses. This combination is a severe strain on the ag viability or on agriculture viability as we continue into 2026. So, what is driving this surge? As we kind of mentioned earlier, first, operating debt across the US farm sector is projected to hit a record high of $624 billion. To survive this margin compression, farmers are having to borrow heavier than ever before. This looks like an average size of farm operating loans jumping by 30%, and banks are lengthening repayment windows because producers have depleted their cash on hand. Unfortunately, this is probably not stopping in 2026. Some recent information from industry bankers have projected that 2027 is probably going to be an even harder year, with, again, more year-over-year bankruptcies increasing. Geographically, this isn't even across the US. Over two-thirds of all cases nationwide are highly concentrated in two regions. That's the Midwest with 121 filings and the Southeast with 105 filings. Both of those numbers are from 2025. These areas have seen an explosive 70% year-over-year increase in bankruptcy filings. On a state level, Arkansas currently leads the entire nation with 33 filings. And unfortunately, this is more than double the 2024 numbers, and it's the highest rate in the 21st century. While there are several factors that contribute to this, it's largely driven by deep per acre losses for rice farms. And behind Arkansas is Georgia with 27 filings so far this year. We're kind of touched on the top of bankruptcy, but before we really look at Chapter 12 and discuss some of the other chapters, what could you consider before bankruptcy? This is a slide to maybe put a pin in as just something to come back and think about if you are considering this. Starting off with number one, reassess your budget. If you're considering bankruptcy, you've probably reviewed your budget 10 times, but I would advise you unofficially, as none of this is legal advice, but I would consider going back for an 11th time. Look for any expenses that you can cut. For example, cable TV, switching to cheaper cell phone options, or canceling streaming services. Once you're down to the necessities like food, shelter, utilities, and transportation, start looking for ways to increase your monthly income. If possible, find a second source of income like a part-time job or an off-farm business. Two, consider selling assets such as used farming or fishing equipment, stocks, bonds, or any household personal items that are of value, and consider using those proceeds to pay down your debt. Have a garage sale, use a consignment service. There are so many options online, whether it's Facebook Marketplace, Facebook Marketplace, Craigslist, name a sector and there's probably an online selling platform. Three, and crucially, talk to your creditors and ideally early. Creditors are the banks, businesses, and individuals whom you owe debt to. Try talking to them and see if they might be willing to work with you to restructure your payment plan or something along those lines. Keep in mind that many lenders are not super aware of how farming and fishing industries work on a day-to-day basis. And this could look like them not knowing how revenue streams from farming or fishing changes throughout the year. So you might walk in being prepared to explain some of the seasonal changes in your income or on your operation. Another really important one, be wary of debt settlement companies. You can personally attempt to negotiate paying a smaller lump sum to settle with a creditor directly. Proceed with caution, though, before using a debt settlement company to advocate for you. There are few companies that are familiar with bankruptcy in general, and even fewer that are familiar with Chapter 12 issues. And debt settlement companies ultimately, they're going to submit a claim that will maximize your savings and negotiations with the creditor for a fee. Remember that these companies make their money from the fees that they charge you, so you don't really have any guarantee of any savings from it. Creditors usually have strong standard policies on how much debt they can forgive. So oftentimes, debt settlement companies can't get better terms for you than you would have been able to negotiate for yourself. Another third one in a row that's really crucial, consider credit counseling. One of your best options when contemplating bankruptcy is to attend a credit counseling course. Counselors or credit counseling meeting. Counselors are trained to assess financial situations, advise on income and debts, and help develop personalized plans for repayment. You can present this plan to creditors during your conversation with them. If your creditor agrees to the plan and you follow through, you might be able to avoid bankruptcy altogether. Now let's take a look at the other chapters of bankruptcy before we dive into Chapter 12. So there are four traditional chapters under the Bankruptcy Code. The first one is Chapter 7. The fundamental purpose of Chapter 7 is liquidation. It's designed to take back all non-exempt assets, sell them off, and maximize cash returns to pay back creditors. While both individuals and business entities can file under Chapter 7, it is the kind of definitive end of the line move because it's liquidation. The court appoints a Chapter 7 trustee if you start the process, and the trustee takes absolute charge of the business assets and liquidation proceeds. Ultimately, filing a Chapter 7 bankruptcy petition brings the business entity, its operations, and its ownership to a permanent end. For a family farm, especially a multi-generational family farm, this is often the worst case scenario. Next is Chapter 11, which is the standard commercial reorganization framework. It has no debt ceilings and it is available to both individuals and corporations. However, unlike Chapter 7, a Chapter 11 debtor does not have to liquidate all assets right out of the gate. The business owner typically acts as a debtor in possession, meaning they remain the physical control of day-to-day business operations throughout the duration of the bankruptcy proceedings. However, Chapter 11 is notoriously expensive, extremely complex, and heavily bureaucratic. It gives commercial creditors significant voting power over whether to approve or reject the debtor's reorganization plan, making it typically a poor administrative fit for a family farm that's working through seasonal margins in their financial situation. And also crucially, there's generally a pretty low success rate for Chapter 11 bankruptcy filings. That number comes in at less than 30% of successful Chapter 11 filings. Filing for reorganization under Chapter 12 is a lot different than what you typically think of as a headline for bankruptcy, especially in comparison to Chapter 7 and 11 bankruptcies. Oftentimes, pop culture or small town gossip can tend to focus on Chapter 7 and apply that across the board. but that's not really the case for Chapter 12 situations. In Chapter 12, you really consider it more of a debt adjustment than a liquidation or traditional bankruptcy. In Chapter 12, instead of selling off assets and foreclosing, individuals are allowed to keep their property and continue farming or fishing while sorting out their finances. When Congress wrote this law in response to the 1980s farm crisis, they understood that a farmer or fisherman's income fluctuates during the year. Stopping all operations to declare bankruptcy could cause them to miss a season and the opportunity to earn income, could have been used to pay down debt. Chapter 12 allows individuals to continue earning their living while working with their creditors to restructure their debts into something more manageable. Oh, I think, Harley, did I just lose my screen?
It swapped screens. You're no longer in presenter view.
Uh, One moment, y'all.
There you
Am
go.
I back?
Yep.
Okay, sorry about that. Um, okay, uh, kind of re-going over that. Chapter 12 is a debt reorganization. It allows you to keep working while you are working to restructure your debt and work with your creditors. Chapter 12 reorganization is available to individuals qualifying as farm operators, as well as business entities, including partnerships and corporations. And then finally, in our kind of brief overview of the chapters, we look at Chapter 13, which is often referred to as the wage earners plan. Like Chapter 12, it relies on a multi-year repayment plan overseen by a standing trustee. However, Chapter 13 is strictly limited to individuals with regular, predictable consumer income. It can't be filed by corporations or partnerships. Additionally, Chapter 13 features much tighter statutory debt limits. This is just under 526,000 or just over 526,000 for unsecured debts and just under 1.5 million for secured debts. Given the massive capital expenditures required in modern ag, where a single piece of machinery or a parcel of land easily could exceed that amount, Chapter 13, just on the numbers, is often unavailable to the majority of farming operations. So, kind of drilling into Chapter 12 and Chapter 13, structurally, Chapter 12 borrows some of its framework from Chapter 13, and they share several key procedural similarities. Both are typically administered by a dedicated standing trustee who reviews the filing, presides over meetings, and supervises the plan proceeds until the repayment timeline is complete. Crucially, both chapters allow debtors to restructure secured debts using the landmark in retail Supreme Court standard, which allows us to adjust interest rates to a standard formula, usually the prime rate plus a small risk premium. And finally, in both chapters, once the debtor successfully completes their court-approved 3 to 5 year payment plan, they receive a formal legal discharge of their remaining eligible unpaid debts. Where Chapter 12 completely outshines Chapter 11 and Chapter 13 is in its specialized legal powers. First, under the Bankruptcy Code, Section 1232, farmers get a significant tax advantage. It allows for the deprioritization of capital gains taxes incurred during the sale of farm assets as part of a confirmed plan. Normally, selling off land or livestock creates a massive immediate tax burden that can sink reorganization. But Section 1232 strips these taxes of their priority status, allowing farmers to right size their operations tax free. Second, look at the statutory comparison between Sections 1222B and 1322B. In a standard Chapter 13, you're explicitly prohibited from modifying a mortgage secured only by the debtor's principal residence. But under Chapter 12, that restriction is removed. A farmer can modify mortgages on their primary residence by bifurcating the unsecured claims under Section 506 of the code, slashing the interest rate, and even re-amortizing the mortgage payment way beyond a traditional 30-year period in order to bring down the monthly payment. Kind of looking at a chart for comparison and contrast, while both chapters 12 and 13 allow for basic cram downs, where a secured creditor must accept, cram down, or surrender collateral, chapter 13 binds the debtor with severe restrictions. For instance, chapter 13 contains the infamous hanging paragraph with a 910-day and 365-day restriction that prevents debtors from cramming down certain vehicle and personal property loans to their actual fair market value. Chapter 12 has no such restriction, allowing full market value cram downs across the board. Additionally, Chapter 13 mandates that secured claims be paid out in strictly equal monthly amounts that provide immediate adequate protection, and lien holders retain their absolute liens until full contract payment. On the other end, Chapter 12 eliminates these rigid monthly mandates, allowing for farmers, again, to completely re-engineer payment structures to match their reality, which is a income cycle that's significantly different from those that are traditionally seeking a Chapter 7, 11, or 12 bankruptcy filing. So how do you classify debt for secured and unsecured claims? To build this successful reorganization plan, you must classify them into three specific buckets: secured claims, priority unsecured claims, and general unsecured claims. The entire blueprint of a Chapter 12 plan relies on this classification because each bucket dictates a different legal treatment. The baseline rule of Chapter 12 is that the debtor's plan must pay off secured claims up to the exact fair market value of their underlying collateral, while generally discharging whatever is left over of the unsecured debts at the end of the 3 to 5 year active payment window. Let's look at how each bucket behaves. Turning first to treatment of secured claims, these are debts that are backed by physical collateral, like a farmland mortgage, or liens on heavy machinery, equipment, and livestock. Chapter 12 gives us the power of bifurcation. This means that a creditor's claim is only deemed legally secured up to the actual and current fair market value of that collateral. If a farmer owes $1 million on a parcel of land, but due to market drops, that land is only worth $600,000, Chapter 12 splits that debt. $600,000 stays secured, and the remaining $400,000 is thrown into the general unsecured bucket. From there, we can execute a cram down. Without needing the creditor's consent, the debtor can modify the interest rate down to current market formulas, stretch out the repayment terms far beyond the original contract, and permanently slash the principal loan balance down to that $600,000 fair market value. Let's now look at how we examine unsecured debt buckets, which are divided into priority and general unsecured claims. Priority unsecured claims include statutory obligations like certain recent tax liabilities and administrative costs of the bankruptcy filing itself. This includes attorney and trustee fees. By law, these must be paid in full through the life of the plan. General unsecured claims cover everything else: unsecured lines of credit, credit card debt, or unpaid balances to general trade vendors or suppliers. To get these debts discharged, the plan must pass two legal hurdles. First, the liquidation test. The liquidation test states unsecured creditors must receive at least as much as they would get if the farm's non-exempt assets were wiped out in the Chapter 7 liquidation. Second, the disposable income requirement. The farmer must pledge 100% of their projected disposable income, which means all revenue left after paying necessary farm operating expenses and family living costs, to the plan for 3 to 5 years. So all of their income outside of basically their necessities to live and operate the farm have to be pledged to paying off that unsecured debt in the 3 to 5 year active payment window. Once that timeline is met, any remaining balance on general unsecured claims is legally wiped away. So, how do we go from classifying our debt buckets to starting a repayment plan? Once we've categorized every piece of debt, we can start working on the formal plan. The document must clearly demonstrate to the judge who's presiding over the case exactly how the debtor will dedicate and submit their future projected income to the standing trustee to fund these obligations. The plan must lay out a clear timeline showing that all priority claims will be satisfied in full unless a lesser amount is negotiated, because 100% of disposable income is committed for that full 3 to 5 year period. For all remaining debts, if you choose to group them into specific categories, you must treat every single creditor within that category equally. And then finally, the plan budget must explicitly account for compensating the trustee's percentage fee and for administrating the case alongside any required court filing fees. When we're thinking of the plan, or when we're considering writing the plan, what steps could we take before to make sure that we've got the best possible outcome for our bankruptcy filing? The reality is, oftentimes, Chapter 12 cases are won or lost before the paperwork is even in, through the pre planned collaboration. Whenever possible, try and engage in proactive negotiations with your secured creditors ahead of time. Keeping your lenders informed early minimizes the likelihood of them blindsiding you with aggressive court objections later on. Take time to honestly assess the posture, specific pain points, and goals of your lenders. Creditor representatives often possess critical historical data regarding your accounts, and it's significantly better to discover these issues early on, instead of waiting till the plan period is under review and dealing with objections from those creditors. To do this effectively, it's important to gather a group of people who can support you and find rock solid data that can back up what you're saying. Build your income projections using trusted third party ag extension services or ag experts to help prove your new plan is actually feasible. What are some more advantages when we look at Chapter 12 and Chapter 13? Chapter 12 offers significant structural advantages due to the realities of the seasonal realities of farming. First, in Chapter 13, your plan is due almost immediately, within 14 days of the filing. In Chapter 12, you have a generous 90 days to formulate and submit your plan, giving you time to evaluate crop cycles or livestock seasons. Second, Chapter 13 requires you to start making plan payments within 30 days of filing before the judge even approves the plan. In Chapter 12, plan payments are not due until after formal court confirmation of your plan. Third, payments can be structured around your farm's actual cash flow cycles. If you only sell grain in October or calves in November, your plan can mandate annual or semi-annual payments rather than equal monthly installments. And finally, there's no creditor voting on Chapter 12 plans. Creditors are allowed to object, but they cannot vote to block it. Farmers can essentially rewrite all of their secured debt, allowing them to re-amortize the entire farmstead without being forced to immediately cure pre-filing defaults. In other words, Chapter 12, while it borrows significantly from the framework of Chapter 13, it's meant to assist farmers in their everyday reality, which is, the same reason we have to have operational loans. It's not common that a farmer has steady average income coming in throughout the year, because the majority of farmers, whether it's in livestock or crops, they're in seasons. So Chapter 12 just looks at what it means to be a farmer and how you operate and tries to match that with the bankruptcy code. Continuing on, Chapter 12, you might hear some people say it's built for speed. It protects the farmer from long, drawn out, and costly legal gridlock. Under 11 U.S. Code Section 1224, the confirmation hearing must be concluded no later than 45 days after the filing of the plan. So once the plan is filed, within a 45-day window, you will have a confirmation hearing where you will figure out whether or not it was approved. You can attend the hearing, and so can your creditors. And your creditors are allowed to argue that the plan is unfeasible or the disposable income was calculated incorrectly, but the court moves the case along swiftly. Additionally, look at 11 USC section 1222B, which we talked about briefly earlier. Under this, Chapter 12 explicitly allows the repayment of secured claims to be amortized over a period longer than that 3 to 5 year window of active repayment in the bankruptcy plan itself. So even if the original banknote matured much earlier, you could end up drawing it out longer. This enables you to stretch a compressed equipment or land loan out over 10, 15, 20, or even 30 years, all in an effort to protect your monthly overhead. So we've kind of got a overview of the different chapters of bankruptcies and or different bankruptcy chapters and options that you might have before filing bankruptcy, but we haven't actually addressed who qualifies. Pursuant to Bankruptcy Code Section 109F, only a family farmer or family fisherman with regular annual income may be a debtor under Chapter 12. The term regular annual income just means the operation's income must be sufficiently stable and regular to enable it to make the planned payments. Section 101(21) defines farming broadly to encompass traditional tillage of soil, the raising of crops, aquaculture, and the raising of livestock or poultry, as well as producing livestock products in their unmanufactured state. However, if you are processing those products into manufactured goods, you can cross the line into standard commercial manufacturing. So kind of keep that in mind if you are in a state of mind to follow the Chapter 12 process. It's possible that the goods that you're actually producing could be outside of the Chapter 12 eligibility criteria. We've got another comparison here. This time, though, we're looking at the family farmer as an individual or the family farmer as a corporation and what some of their limitations are under Chapter 12. So starting off on the left-hand side, the individual family farmer, to be eligible for Chapter 12, your debt cannot exceed $12,565,250. This is the 2026 number. It's adjusted annually and can be small adjustments or larger ones. For instance, a few years ago, I want to say the debt limit was right above $10 million. So there's been a $2 million increase in the Chapter 12 process for this. At least 50% of debt must be farm-related debt. This doesn't include your home mortgage unless the mortgage is unless the mortgage is a farm mortgage. And finally, more than 50% of the debtor's income has to be from farming. This is measured by the previous tax year or the 2 tax years before the previous tax year. Looking at the right side, if we're considering a corporation as a family farmer, we still have the same debt limit of 12.5 million. At least 50% of shares in the corporation must be owned by one family or by one family and farming relatives. More than 80% of the value of the corporate assets consist of assets related to farming. Excuse me, at least 50% of debt is farm-related debt, and the corporation cannot be publicly traded. However, if you fit this criteria, you could be eligible for Chapter 12 reorganization. Turning, we look to the family fisherman, which has different debt thresholds. For Chapter 12 eligibility, a family fisherman must not have debt over 2.5 million. Again, this is the number for 2026. The operation must be a commercial fishing operation, and similar to requirements for family farmers. The debtor essentially must show that the debt arises out of a legitimate commercial fishing operation. The remaining structural requirements, such as the percentage of operational debt and gross income tracks closely to the established guidelines in the previous slide. And just for your view, here are some of the permanent definitions under the bankruptcy code. For example, a family farmer is anybody who's engaged in farming with non-contingent liquidated debts under 12.5 million, where over 50% of debt and income originates from the farming operation. If we look at the 10119 definition, family farmer with regular annual income, that it simply means that your income is stable enough to comply with the Chapter 12 plan. So they're just making sure that you've got sufficient income to make either that quarterly, annual, or potentially monthly, if that's what you chose, repayment plan. This is just essentially a regurgitation of what we've talked about, but I find that a checklist can be really helpful at times. So if you see on the left-hand side, we've got a yes, no box, and then to the right, we have the eligibility criteria. So we ask, are you a sole proprietor of a commercial farm or fishing operation? Is this business your source of regular annual income? Is more than 50% of your gross income generated from the business? Is your operation currently in debt? Is total debt greater than 12.5 million for farmers or 2.5 million for fishermen? Is the debt greater than 50% farm related or 80% fishing related? Have you had a bankruptcy dismissal within the last 6 months? Have you received approved credit counseling in the last 180 days? And then if you look at the bottom, we've got down here, if you answered no to any question, you're likely ineligible for Chapter 12, but may qualify for other chapters. Conversely, if you answered yes to all, you are likely qualified for Chapter 12 bankruptcy. Again, it's similar information that we just covered, but it could be a useful tool if you're trying to quickly figure out whether or not this is something that your operation is eligible for. Within Chapter 12, we have several different types of reorganization. It's important to realize that it's not a one-size-fits-all document. It can be engineered around three distinct strategic tracks, depending on the family's ultimate goal. The first track is a traditional reorganization. The explicit goal here is to preserve the exact nature, footprint, and scale of the existing farm. We use the bankruptcy to reduce overall debt service, streamline operating efficiency, and return the core business to profitability. This track is ideal when a farm is fundamentally sound but was blindsided by a specific isolated financial disruption, like a severe localized drought, a temporary disease outbreak in poultry, or a sudden short-term price collapse. The core legal question for this reorganization is this: we must answer, is the farm truly viable once the debt is restructured? And do your production costs line up sustainably with market prices moving forward? So essentially, the traditional reorganization route questions whether or not this was a truly one-time isolated financial event, or whether it's a sign for something more severe or worrisome in your operation. We've got the second option, which is downsizing and conversion. This is for operations facing systemic long-term market changes that require an operational pivot. The goal here is to deliberately reduce the physical scale of the operation and convert the farm to a completely different or more highly diversified production base. A classic example is a family transitioning away from a struggling wholesale dairy farm and converting the infrastructure into a cash crop or organic produce operation. We have to carefully audit the physical resources of the farm to see what changes can aggressively cut overhead. We ask questions like, will surrendering unnecessary heavy equipment, surplus land, or older livestock immediately increase operational profitability? And will shifting from a strict volatile wholesale market to a diversified direct-to-consumer or local market be effective? And then finally, we have outright sell, which is if there's any Chapter 12 reorganization that's similar to a more traditional bankruptcy, this would probably be it. Sometimes a producer simply no longer wishes to work the farm due to age, health, or an absence of next generation successors. The primary goal here is defensive: save the family homestead and primary residence, but orchestrate a controlled, graceful sale of the surrounding farmland, specialized property, and livestock. Why do this in chapters 12 instead of letting a bank foreclose? Under Chapter 12, the debtor maintains absolute control over the marketing, timing, and execution of the sale rather than the traditional fire sale auction that comes with foreclosure. Further, as we discussed with Section 1232 of the Code, the debtor can utilize special capital gains tax rules to wipe out pretty significant tax liabilities that could otherwise eat up their retirement equity in their operation. The ultimate question is, will this structured plan yield a vastly better, more dignified outcome for the family than a blind Chapter 7 liquidation? This type of plan is typically pretty straightforward, and it just involves the voluntary sale of the entire operation, again, with consideration given to the family homestead and their ability to try and keep that within the family. So we've talked about the plan overall in the last few slides or in the last several slides, but I again think it can be kind of helpful to have a step-by-step process of what Chapter 12 reorganization looks like. So just going from left to right, we have step one: you should consult an attorney. Your attorney will help assess the farm's eligibility for Chapter 12, compile necessary information for the plan, and develop the plan itself. Once the Chapter 12 process is started, it can move pretty quickly, with the whole process often taking less than 100 days. An attorney can ensure that the farmers met all eligibility and plan requirements, saving time, frustration, and money. Step two, you file with the court. Farmers have 14 days after filing a Chapter 12 petition to file all information regarding income, debts, and creditor identities. Oftentimes, this information is filed with the petition, especially when the farmer works with an attorney beforehand. Once a Chapter 12 petition for relief has been filed, a bankruptcy estate is automatically created to hold all of the debtor's property, protecting that property from collection efforts. Step three, you send notice. Once all information has been filed, the court will send notice to all parties. This notice includes the date, time, and location of the 341 meeting of the creditors and others. Step four, the creditor or 341 meeting. This meeting takes place between 21 and 40 days after the petition was filed. The trustee in the case presides over the meeting and asks the debtor to verify under oath the completeness and accuracy of their Chapter 12 petition and schedules. They review additional crucial documents that the debtor must bring to the meeting and ask the debtor other questions related to the filing. And also at this time, the creditor has the opportunity to ask questions. Step five, you file the plan. The Chapter 12 plan must be filed with the court within 90 days after filing the petition for Chapter 12 relief. The court generally grants the farmer's request for extension if the debtor shows the request was made in good faith. Step six, you confirm the plan. Court confirms or rejects the plan within 45 days of filing. Once confirmed, the bankruptcy estate continues during the term of the plan and includes earnings from services performed between the filing of the case and closure, dismissal, or conversion of the case. The bankruptcy estate continues to exist during the term of the plan, keeping the automatic stay in effect, which protects the debtor's property. Step seven, you implement the plan. Plans generally include a date when it will begin, but unlike Chapter 13, there is no set 30-day requirement. Most plans last in that 3 to 5 year period that we've discussed, and they're overseen by the trustee for the entirety of that time. Payments are generally submitted to the trustee, who distributes payment to the creditors. In some districts, courts also have allowed payments directly to creditors, not through a trustee. And then finally, step eight, the discharge. Once the debtor has made all payments required by the plan, the court enters an order discharging all of the farmer's dischargeable debts. If the debtor can demonstrate they have paid at least as much as the creditors would have received in a Chapter 7 liquidation, and the reason the debtor cannot fulfill the payment obligation is due to factors outside of the farmer's control. There may be a hardship discharge or a discharge prior to completion of all required payments. So again, it's overwhelming, maybe with that much detail right in a row, but it's essentially an 8-step process. And as we talked about earlier, Chapter 12 really prioritizes time. That was part of Congress's intention whenever they created this out of the farm crisis. Again, recognizing that the farmers cycle, their seasonal cycle is extremely important for a number of reasons, including that they physically have to be on the farm. And long drawn out court proceedings can really harm their ability to try and make up income that they could pay to their debtors. Um, Bankruptcy forms. So we've discussed some of these, especially in that last 8-step process, but there are a list of general forms which are listed on this page. Under the first headline, we've got the general bankruptcy forms. So this is your petition, Form 101, your Social Security form, your filing fee form, and your credit counseling certificate. There are, under Chapter 12, specific pieces of or specific documents and forms that you have to fill out related to your real estate and property. This looks like a Schedule A, B, and C, contracts and unexpired leases, a list of your co-debtors, your income, your expenses, a declaration about an individual debtor's schedules, and statement of financial affairs for individuals filing for bankruptcy. To declare Chapter 12 bankruptcy, these are all just part of the process. But knowing what these forms are and gathering the required information ahead of time will make your lawyer's job easier, which also puts you in a better place because you're not having to pay per hour for all of these kind of, administrative pieces of the bankruptcy filing. And then just kind of a final note to end on, I want you to have a takeaway. Chapter 12 is arguably the most flexible and powerful restructuring tool in the entire bankruptcy code, but it is underutilized. We're talking today and in general right now about farm bankruptcies because of that explosive rise across the nation. But I want to pivot that statement into saying bankruptcy is not an evil thing. It is not a curse word. It's something that can, especially in the case for family farms, it can allow you both to stay on your land and have the ability to farm again in a normal and hopefully debt-free capacity after the bankruptcy proceedings are filed. I know sometimes it is helpful to have personal examples. I will share one with y'all that I told our team earlier today. I'm 31 years old and I went to law school here in Oklahoma started in 2017. And I was 25 years or 23 years old at the time. And we had our first access to what's called LexisNexis, which is a legal database that lawyers use for a range of different issues. However, one of the things that Lexis gives you access to are public records. And it was at 23 years old in law school that I found out my parents had filed bankruptcy when I was 3 or 4 years old. I've got two sisters. None of us knew about it. My sisters are older than I am. They're 5 and 7 years older. So they, theoretically could have or would have known about it if my parents were discussing it at the time. But the reality is, we were young, and our parents saw bankruptcy as an option to not only relieve themselves of a lot of pressure that had been gaining or that had been gathering, but it was also an opportunity to put themselves and their kids in a better financial position down the road. I've mentioned several times throughout this that the 3 to 5 year window, And that's really generally the bankruptcy window for most people. You've got 3 to 5 years where you are putting all of that extra income toward paying off your creditors. But after that period, you've got the opportunity to basically have a fresh start. Your credit is new. You might have to build it up, but you could still be on your operation. You could still have some form of livestock or crop cycle even during the period of the bankruptcy and the repayment. But then again, crucially, after that period's over, you are back in place and much more knowledgeable for it. And, most people who do go through this process and come out on the other side are not only, in terms of credit better off, but their future endeavors are typically better because it's a process where you learn a lot about finance, a lot about debt, and a lot about changes in the market that can really affect you. So, chapter 12 especially shouldn't be a curse word. I understand it's something that you don't want to have to consider unless you have to consider it. But if that time comes, reach out to people like us here at NAFS, attorneys that you know, tribal or ag organizations that have experience with it, and discuss it. Saying it out loud doesn't mean that you're going to have to file, but it could open up conversation for you to figure out what you need to do in order to get yourself and your family in a better financial position. With that, I will turn it back to Harley and open up the floor for any questions.
Yeah, so we have a couple questions. The first question is there a minimum acreage that you can farm, a minimum acreage of land that can be identified as a farm? They have vegetables and honey on 3 acres.
No. It's again for purposes of Chapter 12, the eligibility criteria is, let me find the definition so I can tell it to you exactly. Um, Sorry. You, for the purposes of Chapter 12 bankruptcy, to be engaged in farming means you are engaged in farming. Engaged in farming with non-contingent liquidated debts under 12.5 million, where over 50% of the debt and income originates from the farming operation. So there aren't any type of minimum or maximum amount of land requirements for Chapter 12 bankruptcy.
Okay. I'm promoting everybody to have the ability to talk, but while I do that, we have one more question. Approximately how much does it cost a farmer for both attorney and filing fees for Chapter 12?
Um, I can get you a rough. So one thing to add to this, filing fees could be different jurisdiction to jurisdiction because states have they've got opt-in and opt-out statutes basically, so they can opt into certain portions of the federal bankruptcy code and they can opt out of others, which can adjust what your filing costs are. But roughly, it's between four and like $8,000 to $10,000, I want to say, is what a lot of people spend on attorneys. Um, Mandatory court fees are usually like in the $500 to $1,000 range. They can be less than that. If you have want specific information on it and want it to be tailored to whatever state you're in, follow up with us after or follow up with me after this, and I can get that information to you. But generally speaking, court fees are not going to be in terms of the overall expenditure for you. Court fees are not going to be that crazy. Attorney fees could vary widely. I think I said like between 4 and 10,000. It could be less than that. It could be significantly more than that. just depending on the size of your operation and how much work there is to do. I'd say a good reminder of kind of how that can fluctuate is debt under Chapter 12, again, can rise up for a traditional farming operation up to $12.5 million. So theoretically, an attorney that's handling two Chapter 12 bankruptcy cases with one of them that has debt at $2 million dollars and the other at $10 million, dollars, there's likely going to be a significant difference in how much the attorney's fees are going to be for that specific case.
Feel free to put your questions in chat or unmute yourself and ask any questions that you would like. Oh, Thomas, that's okay. You don't have to have a microphone or a camera. If you want to ask a question in the chat, feel free to do it that way. Well, while we were waiting for any other last minute questions, I just want to thank the time that Ridge took for us today. This is a very helpful, useful conversation that's hard to have. It's a very hard conversation to have. Nobody wants to have it, but I think that it's very important. We also want to thank our partners at the Southern Risk Management Center, specifically the Ag Tech folks. And so we really appreciate our partners. And oh, he says that the only question I have is it's like 3 acre one. We have 8 raising bees and chickens and raised beds, it looks
Mm.
like.
Thomas, it definitely reach out if you have specific questions or want to provide more information. Generally, though, if you meet that criteria checklist that we went over, excuse me, which said included things like 50% of the debt has to be from farming related endeavors. If those categories are met, then you're totally within the Chapter 12 eligibility criteria on bees, chickens, and plants. Bees may be questionable, but chickens and plants definitely, you're definitely within there.
As we're waiting for any other last minute questions, I did want to put a plug in here that the presentation on June 18th, which will be the third Thursday of June at 2 p.m. Central Time, will be over food safety and like production food safety essentially. And so if you guys are growing any type of plants or have any type of production, then I highly recommend joining us June 18th at 2 p.m. Central Time. Is there any last minute questions? If not, I think you're off the hook easy, Ridge, today. And so
Awesome.
just thank you guys again for joining us. And as always, there will be an email blast that comes out with the link to the recording. I went ahead and put Ridge's email address in the chat. So if you want Ridge's email address before the email blast comes out, feel free to pull it from the chat. If not, I'll make sure that he's copied on the email blast that'll come out either Friday or Monday. And I just really appreciate all the time you guys have here today. And thank you again.
Thank you all.